ICE at hospitals. Your rights in 2026. Do not ignore this update. The waiting room is quiet except for the sound of a child coughing. A mother sits in a plastic chair, her daughter's head resting on her shoulder, a fever that has been climbing since early morning. She came to the emergency room because she had no choice. And then the doors open. Not a doctor, not a nurse. Two men in plain clothing with badges clipped to their belts and questions that have nothing to do with why her daughter is sick. This moment didn't build over weeks of investigation. It built in under 5 minutes. 5 minutes that could interrupt emergency medical care. 5 minutes that could place a parent in federal detention while a child remains alone in a hospital bed. 5 minutes that could end in a removal order served inside the one place every human being has always believed was safe. One wrong response at that waiting room door, and a family that came in seeking treatment leaves in federal custody. What the new enforcement posture around medical facilities represents crossed a line that immigrant advocates, physicians, and hospital administrators had warned about for years. And when that line began to blur in 2026, ICE did not pause. They moved with presence, with coordination, and with a legal argument that most immigrants, and even many healthcare workers, were not prepared to counter. Most people freeze in this moment. They comply completely. They answer every question. They hand over documents they were never required to provide. They assume that a hospital is protected ground, and they are wrong about how protected it actually is. But today, you are going to understand exactly what your rights are inside a medical facility, exactly what ICE can and cannot legally do in that space, and exactly what to say and not say if enforcement ever walks through those doors while you are there. For years now, there had been signals, not from official DHS press briefings, not from formal policy memoranda distributed to hospitals, just signals, that the long-standing practice of treating sensitive locations as protected from immigration enforcement was preparing to change in ways that would be felt most sharply in emergency rooms. ICE had always maintained a sensitive locations policy, yes, but also a pattern of quietly testing and expanding the boundaries of that policy in ways that rarely made headlines until someone was already detained. Their approach followed a pattern, a redefinition, a quiet erosion, almost a deliberate normalization of enforcement in spaces that were previously considered off-limits. But what began alarming healthcare advocates and immigration legal organizations in late 2025 was that the pattern stopped being subtle. The language around sensitive locations protection began to change in official documents in ways that created room for interpretation that had not previously existed. Medical professionals who monitor immigration enforcement trends inside healthcare systems recognize the indicators. The increase in reported incidents of immigration agents appearing at hospitals and urgent care centers in jurisdictions with active enforcement partnerships. The removal of explicit hospital protections from updated enforcement guidance documents without public explanation. The circulation of new legal opinions within DHS arguing that the sensitive locations policy was never legally binding, only a departmental preference that could be modified by administration direction. And the quiet retraining of field officers to treat healthcare facilities with a different classification than they had previously operated under. When an agency starts redefining the rules from the inside without announcing the change publicly, the change is already happening on the ground. Early in 2026, immigration legal networks and healthcare advocacy organizations began documenting what they described as a fundamental shift in how ICE was treating the concept of sensitive locations, including the appearance of enforcement activity at or near hospitals, clinics, and urgent care facilities at a frequency not seen since before the Obama-era Sensitive Locations Memorandum was first issued. These are signals ICE only sends when pursuing something specific. A deliberate effort to eliminate the concept of safe spaces for undocumented individuals, removing the calculation that a hospital visit is worth the risk. A strategy of using the fear of enforcement at medical facilities to suppress healthcare-seeking behavior in immigrant communities, effectively using fear as a deterrent without ever needing to make an arrest. Or a systematic expansion of the locations where immigration enforcement is considered operationally acceptable, with hospitals serving as the test case before the policy expands further. Immigration attorneys weren't certain which objective was primary, or whether all three were being pursued simultaneously under the same operational framework. But one thing was beyond dispute. The assumption that a hospital was a protected space, an assumption that had guided immigrant community behavior for years, could no longer be made safely. And when that assumption collapses, people stop going to the doctor. And when people stop going to the doctor, children with fevers become children with emergencies, and emergencies become tragedies that no enforcement policy can undo. The alert issued by immigrant rights organizations and healthcare advocacy groups this year was not a routine policy update. It was not a general reminder about sensitive locations guidance. It was urgent, specific, and accompanied by documented case examples that made clear the situation had already moved past the warning stage. Attorney after attorney, physician after physician described the new enforcement climate around medical facilities as dangerous, medically destabilizing for entire communities, and most importantly, exploiting the specific vulnerability of people who are sick, frightened, and in the one place where they believed asking for help would not be used against them. But what was also clear from legal analysis was this. ICE's authority at a hospital is not unlimited. There are legal boundaries. They are not the same as they were 5 years ago. They are not as strong as many immigrants assumed they were even then. But they exist. And knowing them precisely is the difference between a hospital visit that ends with treatment and one that ends with detention. Here is what legal documentation, court records, and immigration attorney case files confirmed about what ICE can and cannot do inside a medical facility in 2026. ICE officers without a judicial warrant cannot enter non-public areas of a hospital. They cannot enter examination rooms, patient rooms, surgical areas, or treatment spaces without either a judicial warrant signed by a federal judge or the consent of hospital administration. A deportation order is not a judicial warrant. An IC administrative warrant, Form I-200 or I-205, is not a judicial warrant. These documents are issued by IC itself, not by a court. They do not carry the legal authority to compel entry into a private space. This distinction is critical. It is also the distinction that most people, including some hospital staff, do not know until the moment it matters most. So let's walk through exactly what ICE's presence at a hospital can look like and exactly what your rights are at each stage. The first scenario is officers in the public waiting area. ICE agents can legally be present in areas of a hospital that are open to the general public, a lobby, an admissions waiting room, a parking structure. They can approach individuals in those spaces and ask questions. You are not required to answer those questions. You are not required to confirm your name. You are not required to show any document other than a state-issued ID if you are driving, and you are not driving inside a hospital waiting room. If an IC officer approaches you in a public area of a hospital and asks who you are, you say, "I am exercising my right to remain silent. I want to speak to an attorney." You do not explain why you are there. You do not describe your immigration history. You do not name anyone accompanying you. You say those 2 sentences and you stop. The second scenario is officers asking hospital staff about you. Healthcare workers at hospitals that have adopted privacy protective policies are generally instructed not to provide patient information to law enforcement without a judicial warrant or valid legal process. HIPAA, the Health Insurance Portability and Accountability Act, provides meaningful protection for patient medical information. ICE cannot obtain your medical records without valid legal process. ICE cannot compel a nurse or admissions staff member to identify you, confirm your presence, or provide information about your condition without judicial authorization. However, and this is important, not every hospital has a written policy that prohibits staff from voluntarily providing information. In hospitals without explicit sanctuary-style policies, individual staff members may cooperate with ICE voluntarily, not knowing or not considering the legal protections that apply. If you are a patient or accompanying a patient and you are concerned about your presence in a hospital being communicated to enforcement, you have the right to ask the treating staff directly, "Does this facility have a policy protecting patient privacy from immigration enforcement?" Most large hospital systems do. Knowing that before you need it matters. The third scenario is officers attempting to enter a treatment area. This is the scenario that generates the most fear and where your rights are strongest. ICE officers who approach a treatment room, examination room, or any non-public clinical area must present a judicial warrant to enter. If a hospital security officer or administrator approaches you or your family member in a treatment area and says that immigration officers are outside and want to come in, you have rights in that moment. You say, "I do not consent to their entry. I am requesting that hospital staff require a judicial warrant before allowing anyone to enter this space." Hospital staff are not required to allow IC access to treatment areas without a judicial warrant. Many are trained to enforce this boundary, but they need to know, and you need to know, that the boundary exists and that it is yours to assert. Now let's talk about the scenario that creates the most confusion. What happens if someone in your family is the patient and you're in the waiting room when IC arrives? This is a specific and devastating scenario that immigration attorneys have documented in case after case. A parent brings a child in for emergency care. While the child is in treatment, the parent is approached in the waiting area. Or a spouse accompanies their partner to a procedure and is identified while waiting. The person who is ill is not the one IC is looking for. The person who is present and frightened and alone in a waiting room is. If this happens to you, the steps are the same. Do not answer questions about your identity or status. Do not explain your relationship to the patient. Ask to speak to an attorney immediately. Ask hospital staff to contact a patient advocate. Do not leave the facility voluntarily unless you have confirmed that doing so is safe. In some documented cases, leaving a hospital and walking into a parking lot has moved a person from a protected space into an unprotected one where enforcement was waiting. Stay. Invoke your rights. Ask for legal help. Let's address the question of what happens if IC has a warrant with your name on it. If IC presents an administrative warrant, the Form I-200 with your name and photograph, they're asserting that they have identified you as a removable individual. This document does not automatically authorize them to enter restricted hospital spaces, but it does mean the encounter has escalated beyond a general inquiry. At this point, you say clearly, "I am invoking my right to remain silent. I want to speak to an immigration attorney immediately." You do not confirm whether the name on the warrant is yours. You do not sign anything. You do not agree to voluntarily depart. Voluntary departure signed in a hospital under these circumstances is still a legal document with lasting immigration consequences. Agreeing to leave voluntarily is not the same as having your rights respected. It is the same as having them waived by you under pressure without counsel. Do not sign anything without an attorney present. Let's talk specifically about undocumented parents of U.S. citizen children. This scenario is among the most emotionally complex and legally consequential in all of immigration enforcement. If a U.S. citizen child is in treatment at a hospital and the undocumented parent is detained in or near that facility, the child does not automatically have a guardian presence to make medical decisions. This can create a medical crisis layered on top of a legal one. Before any hospital visit, especially for a child, have a plan in place. Designate a trusted individual with legal status who can make emergency medical decisions for your child if you are not able to. This can be formalized through a simple power of attorney document that your child's doctor and the hospital can have on file. Carry the name and phone number of an immigration attorney with you, not in a password-protected app, but written on a card in your wallet. Know the name of the hospital's patient advocate before you need one. These are not dramatic preparations. They are the same preparations that any responsible parent makes in an uncertain environment. Let's also address green card holders and visa holders who may assume they are not at risk in this context. Green card holders are not immune from IC enforcement. If you have any criminal history that creates grounds for removal, and the list of qualifying offenses is broader than most people realize, a hospital visit where you are identified to enforcement in an unprotected context can become the beginning of a removal proceeding. Visa holders whose status has lapsed, whose applications are pending, or whose situations are in any way complicated by past travel, past violations, or prior immigration court activity should be aware that a hospital encounter is not shielded by status alone. Know your record. Know your current status. Know whether your situation has any vulnerabilities that make an encounter with enforcement consequential. And if you are uncertain, talk to an immigration attorney before a medical emergency puts you in a position where uncertainty becomes outcome. One final and critical point. If you witness ICE enforcement activity happening to another person in a hospital setting, another patient, another family in the waiting room, you have rights as a bystander. You can observe. You can document. In many states and under federal law, you have the right to record law enforcement activity in a public space. You can contact a legal aid organization or rapid response network on behalf of the individual being detained. What you cannot do is physically interfere with an enforcement action. But your presence, your documentation, and your willingness to contact legal support on behalf of someone who cannot do it themselves, that has changed outcomes. That has produced attorneys who arrived in time. That has created records that mattered in immigration court. Do not look away because the situation is not happening to you. In an immigrant community, the situation that happens to one person today is the one that reaches someone you love tomorrow. As 2026 continues and the boundaries around sensitive location enforcement continue to be tested, redefined, and challenged in courts across the country, more stories will emerge of families who face the unthinkable inside a place they went to for healing. But one thing is already clear. Knowing your rights at a hospital does not make you a criminal. It does not make you a threat to public safety. It makes you a parent, a spouse, a patient, a human being who understands that the right to seek medical care without fear is not a political position. It is a fundamental one. Know the 3 things that matter before any hospital visit: the facility's patient privacy policy, the name of an immigration attorney, and who holds emergency authority for your children if you cannot. Share this video with every immigrant family you know. It might protect a parent. It might protect a child. It might be the reason someone walks out of a hospital with their family intact on a night that could have ended differently. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of enforcement unfolds.